A federal judge heard arguments today on California's lawsuit against the Trump administration's response to the protests in Los Angeles. California officials claim President Trump's decision to deploy the National Guard was illegal and unnecessary. The state did not request the National Guard, but the president says he wanted federal troops in L.A. to protect immigration officials. Also on the legal front, there are still some high-profile Supreme Court decisions yet to be announced. That includes the birthright citizenship case that could weaken the authority of federal judges. And CBS News legal contributor, as well as Loyola Law School professor Jessica Levinson, joins us with more on all this. Jessica, let's start in California, where you are. The state says President Trump's decision to send the National Guard to Los Angeles is illegal. So what do you make of the state's argument?
So I think the state, at least in the district court, might be able to win this initial part of the argument. I just finished listening to about 70 minutes of arguments that wrapped up about an hour ago. And it seemed to me that Judge Breyer thought that there were some issues with how these orders were issued, with how the president actually provided the governor with notice. There's some technical issues involving the statute and exactly how the governor needs to be notified and whether or not he needs to give consent. And then there was a separate question where I thought Judge Breyer was dubious about the Trump administration's argument that he could not review questions like whether or not there truly is a rebellion or the danger of a rebellion, those being the predicate facts in order for a president to basically trigger the statute and say, yes, I want to send in the National Guard.
And Jessica, I also want to turn now to the Supreme Court and some of the high-profile decisions we're waiting on right now. First, let's talk about the case stemming from President Trump's executive order attempting to end birthright citizenship. What is at stake here?
A lot. So it's June, it's Supreme Court season, and this is, in my mind, probably the biggest case of the term. As you mentioned, some people talk about this as a birthright citizenship case, but that's really just how it came to the court, where people challenged President Trump's executive order, which, in my mind, is contrary to the 14th Amendment's birthright citizenship clause. But the question for the court is, how much relief can a single federal judge give? Meaning, when you walk into court and you say, there's a problem with this executive order, can the judge say, you're right, and this executive order will not go into effect anywhere in the country? Or is the judge limited to saying, you're right, and this executive order cannot go into effect with respect to the parties in front of me? Obviously, really big implications well outside just the issue of birthright citizenship, as if that wasn't important enough.
And also on the docket, the justices are also considering a challenge to laws that block gender-affirming care for minors. What is the root of that case, and what could the ripple effect of that decision look like?
So this is a case out of Tennessee, and it bans gender-affirming care for minors, but it says that other people who do not identify as being transgender can obtain that care for other purposes, like precocious puberty, for instance. And so the court is looking at an equal protection challenge. The implications here, obviously, as an initial matter, go to whether or not other states could implement similar laws and say that transgender minors cannot obtain gender-affirming care. And I think there's also implications, depending on how broadly the court writes the opinion, for the rights of transgender people in general. What's the level of scrutiny that laws that burden their rights will get under the Supreme Court's precedent? We don't know that yet, and the court might kind of skirt that issue.
Jessica Levinson, thank you very much.